Welcome to the 154th edition of Europe Calling. Today, in cooperation with the member of the European Parliament, Anna Cavazzini, and Maximilian Fries, I'm the head of Europe Calling. I'd like to welcome all of the other guests that are joining us this evening. I'll introduce all of them when it's their turn. Today's topic is the EU Supply Chain Act, and I'm going to be showing you a slide now where you will be able to see how this evening is going to be structured. We're going to start with two presentations by Anna Cavazzini and Reingard Zimmer. After that, we'll have four different blocks, topics: human rights, company size, civil liability, and environmental and climate due diligence. We'll have an exchange of arguments, and after that, we'll have more time to dive deeper into all of these areas, and we'll also welcome your questions. So in the second part, we aim to have an interactive session, but before that, we want to find out what the associations and organizations have to say about the EU Supply Chain Act. Now, a few more technical informations. As always, you can ask questions, and you can also vote for questions via Slido. You use the QR code you can see here. So voting for other questions is very important. We have over 1,200 registrations, which is great. So we'll have to prioritize some of the questions. So do like the ones you find particularly interesting. You can also choose your language by following the link, so you can ask German and English questions. As always, Europe Calling is being recorded. It will be uploaded to YouTube, so do take that into consideration when you ask your questions. These were the technical pointers, and now I'll post a link into the chat, after which we'll start. I'd like to welcome Anna Cavazzini. As you all know, she's an MEP for the Greens and the head of the Committee for Internal Affairs. Since 2019, she's been a member of the European Parliament. Before that, she worked in a number of other positions, including the UN and the External Service, and you've always dealt with this topic, a fair globalized economy. And in an email you once wrote that especially this act, this law, means a lot to you personally, which is why I very much look forward to your presentation. I very much look forward to hearing from you what the state of affairs is in the European Parliament. Dear Anna, you have the floor. Thank you, Maximilian, and thank you to Europe Calling for organizing this event together. It's very important that whatever is discussed in Brussels also finds its way into the public in Germany and other countries, and that's exactly what Europe Calling does, which is also why I'm pleased that we have so many attendees as well as stakeholders here on this virtual arena, so to speak, in order to discuss this extremely important law. There are a number of arguments and different sides to it after all, which is why I think it's important to have a debate. And I very much look forward to hearing what questions the audience might have. I really want everyone to leave this event with as much information as possible, and then perhaps tomorrow you can follow the vote in the European Parliament in live. It was already said in the introduction. We'll be talking about fair globalization. We all know that globalization over the last years and decades has been linked to a lot of benefits. Yes, it brought people out of poverty. It led to welfare, but the worldwide division of labor, including the outsourcing of dirty work with regards to the environment, but also with regards to human rights, well, that is something that has a lot of shadow sides also in the global south. And that is why it is important to tackle these issues. And that's also the aim of the Supply Chain Act that we will be voting on in the European Parliament tomorrow. And that is why it is an extremely important law for me, because over the last years, we always said, okay, a few of the things are good, but other aspects are negative when it comes to globalization, but it was hard to tackle the topic from a regulatory perspective. And that's why, in my opinion, the Supply Chain Act is a true game changer in globalization and can lead to a fairer form of globalization. And that's the incredible importance of this law. It, of course, has a very long preliminary history, and many international bodies have already dealt with it. It didn't simply drop from heaven. Over 15 years ago, the United Nations published the so-called guiding principles in which they clearly stated what would be needed in order to ensure that there are more rules for worldwide undertakings and how violations of human rights could be tackled. And that is why there are many companies that already perform due diligence audits to ensure that there aren't any massive human rights violations within their supply chains. But hitherto, all of that was voluntary. The EU Commission, a few years ago, commissioned a broad survey and realized that 37% of companies do due diligence. That's a good value, but of course it's not enough. And that is why, after having a lot of national laws, we also know the German supply chain law, which was adopted at the beginning of the year, but also in France and the Netherlands, there were legal initiatives, which is why we then said it makes a lot more sense to do something at a European level. It makes sense to have such rules at a European level to create a level playing field to avoid a patchwork within the European Union, which is why we now have this act. 3 years ago, the European Parliament already passed a so-called own initiative report. So they're already politically determined that we as the European Parliament want a supply chain law. And it was already written down what should be contained in it. And back then, it was subject to great support in the plenary. On the liberal and conservative side, the far right was already not on board back then. That shouldn't be surprising. But that is also why the Commission really had a very strong mandate. The Parliament basically told the Commission, please propose a supply chain law. And the Commission then decided to finally follow suit and agree to this a year ago. And ever since, we've had a lot of tough and controversial negotiations within the European Parliament. And this led to this compromise package. And that is going to be tabled tomorrow and will be subject to a vote. As for the process, many of you know this, I'm sure, but perhaps I'll repeat it nevertheless. Tomorrow will not be the final law. It's about the position of the European Parliament. After that, the trilogue procedure will start, where the Parliament and the Council, where the member states are, will once again have to agree. And then at the very end, we'll have the final law. So tomorrow is not the final step, but it is a very step indeed, because the position of the Parliament is the mandate to start our negotiations with the Council. And I am very pleased that the Commission proposal went further than the German law. We discussed this 2 years ago when the law was passed here at Europe Calling. And it is great that we strengthened this law in the European Parliament. For example, when it comes to the company size, i.e. what companies actually have to perform these due diligence audits. Is it only the very big ones or also the smaller ones? Here, we strengthened the Commission proposal, and the compromise package currently foresees that all companies as of 250 employees have to perform due diligence. In other areas, the law was also strengthened. I'm sure we'll go into detail later on, but perhaps I could already name an example. In the German law, only the first supplier is covered. So a big company must only examine what the direct suppliers do. But that's not enough, because most of the human rights violations take place at the beginning of the supply chain. The Commission proposal went further by proposing to include the whole supply chain, but with a somewhat strange concept of established business conditions. And many parties in the Parliament, including the Greens, said that's unclear, that needs to be deleted, which is also what we did. And the compromise now foresees that the entire chain, with the exception of the final consumers, will be covered. So the Parliament strengthened this Commission proposal, which I consider very important. I'd like to once again stress that this is about stopping human rights violations and environmental crime in the supply chains. One last point from my side, before I pass the floor to the other speakers and stakeholders. I said it at the beginning, the law has been subject to controversy, and we'll certainly realize this evening. And I think it's important to listen to all opinions and to elucidate all sides of the argument. There has been a lot of lobby pressure against this law to soften the law, to integrate loopholes. And at the moment, the law is still being controversially discussed in the conservative group. There are going to be amendments, so there will be an attempt to soften the law by the extreme right, but also from the conservatives. And it still isn't clear what amendments are going to pass and which ones won't pass, or whether this broad consensus is going to be subject, or this compromise is going to be subject to broad consensus. So it's going to be a very interesting vote, and I'd very much welcome it if all of you watch it tomorrow. That would be it for now. I wish all of us a great discussion and event, and I'm very pleased that this event has been or is subject to so much interest. Thank you very much indeed. In that case, I'd like to give the floor to Professor Reingard Zimmer. She is professor for economics and law at the University of Berlin and is an expert when it comes to international labor law. And she is closely following all matters relating to the supply chain, especially when it comes to co-determination and the trade union side. And I now very much look forward to your presentation. Professor, you have the floor. Very well. You should all be able to hear me now. Thank you very much indeed. It is a true pleasure to be amongst you. And I was asked to speak about the differences between this proposal and the German law. And that's exactly what I'm going to do with the help of a PowerPoint presentation, because that allows everyone to perhaps follow what I am saying a tad more easily. I'd like to speak about the differences and commonalities of what you just called the EU supply chain law. It is, after all, a directive, which is why I wrote RL Entwurf, which is the German abbreviation for directive draft. There are many commonalities because it's all about obliging companies to perform a risk assessment. And that means auditing and testing to what degree their activities might change human and environmental laws. That includes labor laws that are based on conventions of the International Labour Organization. We just heard it. We now have this draft directive, and the demand of a permanent business relations has been taken out after negotiations in the Parliament. I would be very pleased with this, because when it comes to this, in my opinion, the German law is a tad more far-reaching, because we don't have a limitation to the first supplier. Through the back door, the whole chain is added. And according to the German law, we're not limited to a permanent business relation. But what would be good if there was the possibility to make companies liable through this directive. So what does that mean? Well, if affected persons can sue a company to receive compensation or damages. The guiding principles have already been mentioned. In 2011, The guiding principles for business and human rights were adopted with these three pillars: protect, respect, and remedy when it comes to violations. These were implemented via the national action plans. In Germany, this took place in 2016. In France, in 2017, one passed a law, not national recommendations, a law called the Loi de Vigilance, which is quite similar to the German law, which I will present in more detail later on. Our law was then adopted in 2022, so it's fairly new. And the directive, if it is to come into force by the end of the year, or if it is to be adopted by the end of the year, I am an optimist after all, then the member states would have 2 years' time for the implementation. So changes to the German law will definitely take place. The scope of the German law is such that only the really big players are covered. So companies with more than 3,000 employees, but temporary employees are also considered as long as they are employed for more than 6 months. As of next year, the scope is going to be reduced. As of next year, this will also encompass companies that employ more than 1,000 employees. In the draft of the Commission, at first, the idea was to have over 500 employees and over 150 million euros of yearly sales. If this was to be brought down, it would be great, but we can see that this is a significant improvement compared to the German scope. In the directive, it was foreseen that if companies have less turnover and fewer employees, but nevertheless operate in so-called risk sectors, that those would also be covered. Should an improvement come about tomorrow, that would be great.
Lasst mich auf das deutsche Gesetz noch einmal eingehen.
Okay, now I would like to get back to the German supply chain law. How far does the supply chain go? All services are included and all products of the supply chain of a company. This term of supply chain, I must say, I do not particularly like, because it would be better to talk about a value chain, because supply chain always suggests a product will be delivered at the end, but we're also talking about services. Explicitly, services are included with all the steps abroad and in Germany at home, which are used to produce the product or to provide the service. This includes also raw materials extraction. And there is a differentiation in the German law between a known business area and the acting as a direct supplier. And furthermore, there is a graduated responsibility. The indirect suppliers are included via the back door, but with a very staggered and graduated responsibility. What kind of due diligence obligations are we talking about? First of all, a company, and I had already mentioned that, needs to introduce risk management, which means they have to stipulate who is going to do that within the company. There needs to be a basic statement. This is a public statement where everything is being explained. The procedure is explained. And this also includes the implementation of regular risk analysis once a year. These risk analyses only apply to the own company, to the own group, and to direct suppliers. And on the basis of what is found out during this analysis, expectations of the employees, a kind of a code of conduct is being worked out. This also applies to the suppliers. And as far as the employees are concerned, we have co-determination via the Works Council Constitution Act. That means the company cannot at all do that alone. That is not allowed. They really have to adhere to the proceedings. Again, on the basis of the risk analysis, preventive measures are going to be introduced in the own business area as well as vis-a-vis the direct suppliers. And again, here you see the graduation. If there is a violation, remedial actions have to be taken. And that is very important, it is really a central point here. We need to have a complaints procedure in place, a grievance mechanism, which applies first of all to the own business area and direct suppliers, but not exclusively. And this is the back door I mentioned before. Violations of environmental, of labor rights of an indirect supplier are included as well. So this is along the entire value chain. And I will talk a bit more in detail about the complaints procedure, but I would like to mention other corporate due diligence obligations. There has to be a documentation internally. There has to be a reporting once a year, and this has to be published on the website. The problem is always that if you do not have proper criteria, there are criteria, but they will all, look bright and shiny in the report, and there is a bit of a wishy-washy problem we might encounter. As far as the indirect suppliers are concerned, there are due diligence obligations, and this applies if there is a substantiated knowledge of a violation, a factual indication of the violation. And that means that the company also has to start with a risk analysis pertaining to this company further down the value chain. And they have to put prevention measures in place. So through that back door, we also have something in our German law concerning the indirect suppliers. But I agree with the previous speaker that this is not sufficient. Now I would like to say a bit more about the options for actions by the employee representatives. First of all, the Economic Committee. The Economic Committee is an accessory body of the Works Council. This Economic Committee is responsible to gather information, economic information from the employer, from the company. There is a catalogus which includes the questions which they can ask. This is according to Article 106, and this was extended by an additional stipulation. And this now includes questions regarding the corporate due diligence. That means the Economic Committee got a direct mandate now to deal with exactly that topic. And they will have a look at the general statement and will check it. Questions can be asked. How do you plan, for example, the risk management? What kind of procedures will you use? Who is responsible internally? What are the criteria? Who is the human rights officer, for example? This is very important, whether this is a person who can actually do something about it. These are the questions that can be asked. Furthermore, what is the planning regarding prevention and remedial actions, for example? And very important, there is a complaints procedure. How is that developed? And this complaints procedure, this grievance mechanism, includes also, at least partially, a co-determination of the Works Council. The members of the Supervisory Board, and I am now referring more of the employees' representatives within the Supervisory Board, but of course this applies to the entire Supervisory Board. Already before this law entered into force, they were obliged to monitor risk management and compliance measures because their task is to supervise the work of the management. And in case of a public limited company, there is a special audit committee who is doing that. And since the beginning of this year, this includes the monitoring of the compliance with the obligations on the basis of the German Supply Chain Act. Now I would like to mention a bit more details about the Works Council. GBR stands for Central Works Council, and KBR is the German Group Works Council abbreviation. There is no explicit regulation by the legislator. The Works Council Constitution Act was not extended, but we have several areas where the Works Council representatives can ask questions concerning the supply chain. And we have an explicit co-determination. And that means that the employer alone cannot act. Generally, the Central Works Council is informed via the committee I mentioned earlier. And there are general legal provisions they can use. For example, according to paragraph 80, paragraph 1, number 1, they are responsible for monitoring the legal provisions. And this includes also the legal provisions within the Supply Chain Act. This is a weak law because they only have a right to information. Furthermore, this can be made public to all the employees, for example, during meetings, and this can also be made publicly known. Furthermore, we have the mentioned co-determination rights, and I am now referring to Article 87, paragraph 1, number 1.6, and this code of conduct concerns the expectations of the company towards the employees. What do they expect from the employees? And this needs to be agreed upon with the Works Council unless there are non-binding ones. And this includes that violations of the Supply Chain Act need to be reported. They have to be reported to a special position or a special officer. This means that the Works Council has to be included, and if they cannot agree, then there is going to be a special body which will really take a decision there. So this is a strong law. The same applies to the complaints procedure, which can be used through the entire value chain, but also via or on the basis of complaints by individual employees. And this is now a point of the Works Council Act in Germany. This is the same procedure as I mentioned earlier about co-determination. And we have another paragraph 6, because there is also a technical tool which can be used for monitoring a telephone installation, for example, where you can backtrack telephone calls, etc., or an online tool. This is just something, this is actually a short information I was able to give you, but I do not want to extend the time limit I was given, and I thank you very much for your attention. Thank you very much, Mrs. Zimmer. And I would like to ask immediately, because I saw some questions coming in, what you mentioned about the possibility to participate. What do you expect? Do you expect that via this supply chain directive, which will be transposed into national law, do you expect an amendment of the German Supply Chain Act on the basis of what you have heard and know from the European Parliament? Absolutely. As far as the participation possibility is concerned of the German Works Councils, this is a very Germany-specific topic. In the other countries, we either have no Works Councils, or we have trade union representatives, or we have Works Councils which are only organized on a trade union basis. This is slightly different. I think the areas I mentioned very briefly as far as co-determination is concerned, I think we will probably not see an amendment of the German Act. And if so, it will be only a very slight amendment. We, of course, also have bodies like the European Works Council, and this is an ideal body because they have representatives of different countries there, and they could also deal with that topic. We will have to wait and see, but the act in general will be changed and will be improved, and this is good news because that means that the possibilities for trade unions will be increased, as well as of the actors in the company. Thank you very much. That is important. Anna Cavazzini, maybe you could answer another question. I just have a few questions I would like to ask immediately. This was more one for you. This is a question that was put in English.
President of the Backway Cocoa Farmers Association in Western North region of Kenya. How was producer countries involved in the process?
Danke für die Frage. Ich finde es auch sehr, sehr gut, dass
Thank you very much for that question. And I must say it is great that we have such an outreach, such a huge outreach, and that we have representative stakeholders from the Global South here. When the Commission worked on this directive, they had a lot of discussions, me included. We had a discussion with representatives from the Global South, and we of course listened to their opinions. And I think it is great that the European civil society has and will always have partners in the Global South, and they will always be included, and they were included in the different discussions.
Dann,
okay, thank you very much for that. And now we continue according to our agenda with our associations and organizations. And as I said earlier, we will do that according to topics. And for the first topic, that is the topic of human rights, I would like to ask Eva Maria Reinwald. She is expert promoter for global business and human rights at Südwind, to talk to us. Furthermore, Matthias Lange, he is executive director of the Cocoa Coalition Business Association. I think that's what it is, and I summarized it in German now. I would like to ask the two participants to say something and give us a statement, a highlight on this topic, and then Mrs. Cavazzini and Professor Zimmer will answer. Just 1 minute, they will reply. I do not always repeat that from now on, because then this will be a never-ending story. Then we have further one question back and forth, and then we have a bigger round. You have the floor. Yes. Thank you very much. The respect of human rights, we need important progress, and the obligations will apply to the entire value chain. And that means that plantations, for example, and mining areas need to get priority. And this is also important for the processing of products, for example, for the export of hazardous goods like pesticides. And they have to include all these obligations, and the environmental needs need to be mentioned further. The partner in this chain need to know how important the right is for a life full of dignity, the adhering of these obligations, and that the compromise shows that is very important. For example, those workers in the shoe industry who work at home and they are paid by piece, and they have to include all the family members in their work because otherwise they do not earn enough, that these problems are addressed is important, and the individual companies need to change their purchasing policy. Very important for human rights is the financial sector as well. Tomorrow, the members of parliament will have separate discussions about the asset managers and the institutional investors, because they have quite an influence. What is positive is that the rights of indigenous people are taken into consideration, and the ILO Convention for Safety and Health at the Workplace, and that there are endeavors to weaken this directive, for example, in terms of the downstream positions, this is a difficult thing to digest. Thank you very much. Now, Matthias Lange. Lange, he is representing the Cocoa Coalition. You have the floor.
Yes, thanks. And despite my very German name, I'm going to speak in English for those who want to switch translation. So I'm indeed representing the Cocoa Coalition. We are a group of companies, but also importantly NGOs, certification organizations, and multi-stakeholder organizations like mine, the International Cocoa Initiative. So that's been a great gathering of diverse organizations, which has been extremely powerful in order to push for a transformative due diligence legislation, both that one on human rights and environmental due diligence, but also the deforestation regulation. So we are very pleased with the regulation, and while that's been the product of a compromise, we believe that the text of the jury committee is quite ambitious, and we are very pleased to see the inclusion of a number of important elements, such as the right to a living income, the impact of purchasing practices, or the use of disengagement only as a last resort. However, I'd like to stress 3 points tonight. The first one is that, legislations are great, and that specific legislation is very good, but legislation is not enough. So all those human rights and environmental issues we are talking about tonight have a lot of root causes that also need to be tackled by governments in producing countries. And as such, the EU also need to provide support to those producing countries so that those issues can be addressed. So we also need partnerships with those countries. Corporates cannot solve all the issues on Earth on their own. My second key message is that, the legislation is great, but legislation in itself is just a piece of paper. So enforcement is going to be key. That's just the first step in a long journey, the adoption of that legislation, and we very much hope for a positive vote and then a positive trilogue dialogue afterwards. But enforcement is going to be absolutely key. We need to make sure that this is not just going to translate into a massive auditing business, but in something that can really leverage the transformative power for people on the ground. And my last message is really let's make sure that this legislation is delivering for those for whom this legislation has been developed in the first place. So at the end of the day, we are talking about smallholder farmers in sub-Saharan Africa, factory workers, miners. So let's make sure that the burden of the legislation fall on the companies, especially at the top of those value chain, and not on those smallholder producer farmers, but that this delivers a positive impact for them. Thank you.
Vielen Dank. Dann hole ich jetzt Anna Cavazzini.
Thank you very much. Then I'd like to ask Anna Cavazzini and Mrs. Zimmer to take the floor. You can perhaps respond to what has been said. We'll see how this works out, and then we'll move on. Anna Cavazzini first, and then Mrs. Zimmer, and then we'll go back. In the European Parliament, we always have 1 minute of talking time. So I'm very used to only having 1 minute. I'll try to be as brief as possible. Matthias Lange is indeed a very German name, and you said that a law doesn't suffice, and you're right. The root causes have to be tackled. And here it's very important to have an exchange with the governments also in the Global South. That is definitely the case. But I think we need to do this via cooperation in the areas of development, via the Global Gateway Initiative, etc. So I think there are other tools here too, but it is indeed very important. But perhaps to turn around the argument, what I often hear is, well, these issues cannot be tackled by Europe. This can only be done by governments in the Global South. You didn't say this, Mr. Lange, but I hear this often. Well, the past years have shown that that is something you cannot rely on, and that often multinational companies or other suppliers take advantage of weaker laws or of weaker implementation mechanisms in the countries of the Global South, which is also why we need this law. Thank you very much. Mrs. Zimmer. With regards to 2 points, I'd like to say something. Now, firstly, implementation is, of course, of central importance. what is written on paper is only dead law, so to speak, if it isn't implemented. And I am also here to stress the company and trade union actors, and I'd like to point to global tools that already exist, international framework agreements that were concluded between international trade union associations and individual companies. And here the assurance of the same laws have been concluded. Complaint mechanisms have also already been concluded. And this way you can get in touch with the member trade unions in the Global South. And if such agreements contain the right to access, for example, different locations in the Global South, that are really very useful. So these tools are also very useful, in addition to all the other tools that have already been mentioned. These are important for the implementation. And the implementation must, of course, also occur on the side of the company. For example, when it comes to purchasing policy, I can only agree with what has already been said. If there is no room for maneuvering in the Global South for the local producer, then the wages aren't going to be sufficiently high. And then this begs the question how the bodies in the EU member states, well, how strictly they control and whether they also apply the law in a strict fashion and actually also impose big fines. If this was the case, it would be good. But if one lets everything go through, as long as one uploads a nice declaration and leaflet, then this won't be of much merit for the implementation. Thank you very much. Then Eva Maria Reinwald once again has a minute, and then Mr. Lange has a minute, and then both of you will have another minute to react. Mrs. Reinwald, thank you very much. In my opinion, the compromise that was found in the committee also places value on the purchasing policies of companies. That is a big success. One is also going to pay attention to how companies conclude their contracts with the suppliers. And the due diligence obligations, for example, cannot simply be passed on. There must be fair agreements between the company and the suppliers. And here the proposal is indeed pretty good. Another aspect are the trade unions at a local level that have to be included into the development of measures when it comes to implementing due diligence obligations. Because I alluded to it and because it's very close to my heart, I'd like to speak about the role of the financial sector. Banks and insurances, for example, can award credits and thereby also ensure that one doesn't invest into the human rights violations. There is one thing that was found in the compromise that wasn't so good, and that is that this is only the case for direct larger customers, and we'd like for improvements to come about in this framework of the trialogue. Apart from that, I agree with the previous speakers. A law is an important step towards a sustainable and human rights-based business practices, but this must also be accompanied with all actors such as the trade unions and the human rights activists. Thank you very much. When I nervously wave my hand, and that usually means that you've exceeded your speaking time. But we aren't a party campaign arena here, so all is well. Matthias Lange, please, you have the floor.
Yeah, no, thanks. I'd just like to build on 2 points. So one is, again, that law is meant to serve those that are at the bottom of those value chains. So again, the farm workers, smallholders, and so on. So we need to absolutely make sure in the implementation that it doesn't lead to things like companies turning their back out of at-risk countries, and also making sure that this, again, serve them and don't push additional burden on them. And here I'd like to build on the point that has been made by Prof. Zimmer on the importance of those administrative bodies, but also the court who are going to assess the implementation of the law. That's going to be absolutely key if we don't want that to be just a tick-the-box exercise which is going to provide jobs for people filling in reports, but again, making sure that this is something that leverage the transformative power of this extremely important law. Thank you very much.
Herzlichen Dank. Dann beschließt das
Thank you very much. That concludes our first round. We'll now move on to the second round. And when it comes to company size, well, we already heard quite a bit about it today. I'd like to invite Holger Kute, who's the head of the European Office of the VDMA, the Association of German Machine and Equipment Constructors. And I'd also like to welcome our second speaker, but we'll start with Carola Dittmann from the IGBCE. Carola Dittmann, you have the floor. Thank you for being here. Your microphone is still deactivated, I believe. The usual issue. Thank you very much for the invitation, first of all. A lot of important things have already been said. Generally speaking, we welcome this scope because it is a lot far-reaching already than the German law. It also includes financial companies, even though there are some weaknesses that have already been mentioned by the previous speakers. Generally speaking, we agree that due diligence obligations cannot be measured based on a company size or the number of employees. Also, small companies can have terrible effects on labor or social standards or sensitive ecosystems. And that is why we believe that also small companies from risk sectors need to be included into the scope of the directive. We have the experience from Germany that there are a lot of touch points here. It is important to have a structural integration of employee representative bodies and trade unions in the implementation of due diligence obligations because labor rights are, after all, human rights. There's a lot of support amongst trade unions for this directive, as proven by a declaration of the Works Council that was published today in support of the directive. This was signed by 36 Works Council members around the world. What's also important to me is linking company interests with important sustainability goals, including the consequences on human rights. That this responsibility lies within the management, and that management is also responsible for the due diligence process. That is something we very much support. Thank you very much. Then, Mr. Kunze. Thank you very much for the invitation. We have a somewhat more critical view of the directive, and I'm very pleased that I have the opportunity to briefly explain why that is the case. I'm speaking on behalf of a sector which is the largest industrial employer in Germany. It is a sector that is also dominated by mid-sized companies, by small companies that have global networks and also operate on a global level, not only when it comes to exports, but also when it comes to being supplied. These often family-led companies are known for fostering social cohesion and for considering human rights extremely important. And these are companies that already practice today within their undertaking in the supply chains. What is now to be decided in the European Parliament is, however, going to burden companies in our sector to such a degree that it might not be doable. Why is that the case? Well, when it comes to machine construction and engineering, we're often talking about highly complicated products that aren't manufactured in series. They're often individually manufactured together with the customer. And these complex products are often composed of hundreds of parts. And these parts are sourced at a global level. And if you go beyond the first step of the supply chain, then you quickly have a higher potential of contacts that would have to be analyzed within the framework of the risk assessment of this SME. And this isn't doable for the SME in our sector. So the situation is simply different to the situation in the chocolate or cocoa industry due to the way the industry is structured and due to the way in which the products are composed. So at the end of the day, exactly what the previous speakers have said is going to happen. Such a supply chain act is simply going to be a ticking box exercise where certain checklists are looked at, but where in practice not a whole lot is going to change. And that is why we believe that this isn't of service to human rights. And that is why we believe that this should be subject to further thoughts and discussions. Thank you for these clear words. That's exactly why we're here. It's great. We now have something to discuss. Thank you very much. Mrs. Zimmer, Anna Cavazzini, perhaps you could react. Perhaps when it comes to this topic, Mrs. Zimmer could start, please. Thank you very much. I would like to reply to what Mr. Kunze has said. He said that social values and that cohesion are important for SMEs. But if this is to not only be the case for Germany, then we need such rules. As we all know, we have global networks, we have network structures, and in machine construction, the supply chains are a lot shorter than they are, for example, in the textile sector. So the difficulties should be somewhat less pronounced. And of course, certain solutions could be found at a sectoral level. Not every small or mid-sized company has to set up its own complaints mechanism. One could have a sectoral solution that is accessible, as is also required by the German law already. So that would be one possibility to also minimize the costs. And also when it comes to the risk assessment, there could be a sectoral approach.
Reine kosmetische Maßnahmen und Absichtserklärungen und schöne Worte reden
wollen. If we really want to do something here, if we want to be responsible and ensure that better working conditions prevail, then we have to take a look at this within the worldwide systems. Thank you very much. Anna Cavazzini. I too would like to respond to Ms. Dittmann. In the Parliament, and there was a lot of agreement here. We wanted to strengthen the role of trade unions because we too believe that trade unions play an extremely important role when it comes to actually implementing this law, be it via the stakeholder consultations, be it via complaints mechanism, but also by strengthening trade unions and thereby also eliminate whatever issues might arise. And you rightfully analyzed that the company size isn't really the most important thing. And I also heard this from a number of companies. Mr. Kunze, perhaps you could also say something about this, because there are companies that are active in high-risk sectors and others that aren't. So it's not really about the size of the company. As the Greens in the Parliament, we try to go down that direction, but compromises are compromises. And at the end of the day, we reached this threshold of 250 employees. But perhaps one more sentence, if I may. And this has already been said a number of times today. In Parliament, we now have this risk-based approach that we agreed to. This also complies with UN and OECD standards. And I think this will somewhat take away the fear that a lot of these SMEs have. One has to perform a risk assessment and develop a strategy to tackle the biggest risks. And I do believe that this can be handled. Thank you very much. And back to Mrs. Dittmann and then Mr. Kunze. Perhaps I could also briefly respond to what Mr. Kunze has said. And I could perhaps also speak about an experience we have made in the German chemicals industry, together with the employer and employee association. We launched a so-called sustainability initiative, which has been ongoing for 10 years now. And in this framework, we came together with companies and also with SMEs that are extremely active here already. And we developed a sectoral standard which provides support for companies of all size. Something similar is now also to be seen when it comes to the sectoral dialogue in Germany. So I agree with you. It's somewhat difficult to do it all by yourself. Of course, an analysis has to be performed. But if you do come together, a lot more can be achieved. It would be terrible if this law would become a tick-the-box exercise. Of course. Mr. Kunze. Perhaps with regards to what Mrs. Zimmer said, I'm not sure where you have this information from, that the supply chains in our industry are short. That's definitely not the case. We have extremely long supply chains, and that exactly is the issue here. I would like to beg for your understanding. We are an industry that produces over 20,000 different products. So we have a huge degree of differentiation, and this is also hard to depict in a sectoral agreement. And at the end of the day, Mrs. Cavazzini, the risk assessment will have to be done by the company. And a risk assessment is cumbersome. That is also part of the truth. And we'd be very much in favor of also focusing on that. Thank you.
Sind wir jetzt hier bei der Halbzeit? Ich sage noch mal für alle, die vielleicht dazu.
Okay, it's half time now. I would like to say the following for those who joined us. We are now talking about different highlights about the directive. We have now reached half time. There will be another two rounds, and then after that you will have the possibility to ask questions. And I will also post that into the chat. You can put your questions on Slido, and then we will have a general round of discussion. Now we have our third topic, which refers to civil liability. And that means at the end of the day, if the Supply Chain Act is being violated, Mrs. Zimmer has to leave. Bye-bye. Thank you very much, Mrs. Zimmer. Those victims can ask for compensation. They can go to court. If that was too simplified, you can, of course, contradict that. But I'm very pleased that we have two guests. First of all, Ralf Kamphöner. He is the head in Brussels of the Textile and Fashion Association, as well as Nele Meyer. She is director of the NGO European Coalition for Corporate Justice, ECCJ. And in that case, I would like to start with Mr. Kamphöner. Nice to have you here, and you have the floor. Yes, thank you very much, Mr. Fries. It's a big round. I'm happy that we talk with each other, that we have different opinions on the table, and that we sort all that out afterwards. Maybe I can start by saying something about those who should take over civil liability. And you mentioned the exemptions for SMEs. That doesn't really help, I must say. I heard something today where they said the big companies, they are the contracting partner of the small companies, and at the end of the day, also the small companies will be liable. Despite this exemption for SMEs, everybody is at the end of the day liable. And this civil liability has a kind of a catalyst effect for all the other parts of the directive on the supply chain. Everything that is put into as a provision will be even stronger in its effect because of this civil liability provision. And therefore, everybody, the companies especially, need to know what they have to be liable later on for, and something needs to be controlled. They have to control that. Is it possible to do that? Yes, in Germany, we have an article in our German code of law, and if you know the history, you know how long this was disputed. This is a very fine balance, and this includes possibilities, probabilities, and there's a very fine balance that has been struck there. If you want to be fair to the companies, you have to make sure that there's a limitation, first of all, a limitation concerning the own company, the subsidiaries, and the clients, the suppliers of the first level. Why is this important for smaller companies? Imagine a shirt like the one I'm wearing now. There are so many people who contribute to that. This can be a dozen up to 100, and therefore it is necessary that you can only put the liability and to limit the liability to that what the companies can really do. And I've completed my time limit. Yes, thank you very much. And now Nele Meyer has the floor, representing ECCJ. Thank you very much. Thank you very much for inviting me. And thank you very much, Mr. Kamphöne. I am not giving you my statement because I will immediately react, because you actually already presented some demands. What is important, and this is also the idea behind this law, is the principle that those who are actually providing a damage have to be made liable for that damage. And in our global society of today, this means this also concerns all the other parts of the supply chain. And this is not the case at the moment. We see so many victims at the moment who have not the possibility to go to court, or even if they go to court, they do not have the possibility to get compensation, financial compensation. And this is the principle, that victims really finally have access to justice and to financial compensation. This is important. You say it has to be clear. Civil liability in all three positions, which is in existence, is very much limited to the civil liability which exists in all countries. It's based on that, and this is based on causality. That means the liability is not an equivalent to the due diligence obligations going through all the supply chain. They only talk and refer to the causes, so the causality. Everything you already mentioned, this means this is already a perfect state it is in now. A causal connection, either because you are the one causing it or you are part of the cause. But what happens? We see attack everywhere to this concerning these liabilities. Companies say, no, we do not want to do that. For example, they foresee procedural problems to go to court. All of that is really endangered. And I must say that we're also disappointed by Parliament. And if you talk about this German law 800, etc., that means it had to be an intentional damage. And this does actually contradict the standards we want to have. The principle is that those who are causing the damage have to be the ones who compensated, irrespective of whether it was intentional or not. Thank you very much. Mrs. Cavazzini now has the floor, because Mrs. Zimmer has left already. You have now 2 minutes actually to answer. Okay, I nevertheless try to keep it short because I have the possibility to say quite a lot here. My impression is, as Member of Parliament, and I participated in many negotiations, that liability was always the most disputed topic, indeed. And I think listening to what companies are also saying and talked about, there was a lot of fear, but that was actually not founded. They often said, okay, if we have this directive in place and then we have the liability, then I'm basically already in prison, more or less, with one leg in prison. This is not the case. And Mr. Kamphöner had already said that basically there are clear rules when liability will be enforced. And if it has to do with the fact that if as a company you have actually seen a risk, but you haven't done anything about it. In the case of a textile company collapsing, for example, and a mother victim of a human rights violation who died, and then she went to court because the mother died, the daughter went to court, but that did not hold in court. And it is very important that these victims of human rights violations get a compensation. Therefore, this directive closes a very important gap, but doesn't mean that you're basically going to prison. If you are looking after your due diligence obligations, then there's nothing to be afraid of. Mr. Kamphöner, maybe I can add 2 points. The principle, and I think everybody understands that one has to treat everybody fairly, all the companies. We have a tradition in Germany, in the family companies, where this is already the case. They do that by themselves. And I would like to say something about the role of the state. I must say the state leaves the companies alone. And the Export Control Act was mentioned, where basically the companies get a list where they can read where and from which countries they can buy. This does not exist here with this directive. The companies are responsible themselves. And secondly, what are actually the consequences? What are the consequences if this liability risk now lies with the companies, or if I increase it? They have a conflict. They say, okay, I reduce my suppliers. That means I import from fewer suppliers and from bigger companies there. And well, we are damaging ourselves here. If we want to diversify all these international supply chains, what the EU actually wants. There was a very interesting study from an institute in Kiel. I cannot go into detail, but please think about that, because you are now actually attacking or doing something with the market, and this could really lead to serious concerns. Thank you very much. This is something I would really like to discuss in a bit more detail later on during our discussion. I think this would be great with more participants. Mrs. Meyer, please. Yes, I would like to get back to these 2 points. The increased liability risk you mentioned, and I would like to support Anna. She said these due diligence obligations are now made clearer, and that means there's a higher level of certainty for the companies, what will be expected from them. As far as liability is concerned, the following questions are asked: what was to be expected from the company, and which right was violated that actually led to the violation? And I think there is more clarity and therefore more certainty. And the liability risk hence is reduced, is smaller, because now there are more and more support measures in place in order to support smaller and medium-sized companies to fulfill their obligations, their due diligence obligations. Will the market shift? That was a question which was discussed with the Conflict Minerals Act. And This concerned measures in the area with big lakes in Central Africa. And what happened, indeed, activities shifted, first of all, after 1 or 2 years, companies returned into this region and they continued their economic activities, but in a different way, because they did adhere to the due diligence obligations. And therefore, our experience is that it is not a deterrent. No, it really leads to a change in the commitment of the business activities. Thank you very much. And now I start with our fourth and last round. We talk now about the environmental and climate due diligence obligations. I welcome Ceren Yildiz. She is Research Associate, Environmental Protection in Supply Chains at the Friends of Earth Germany. Good evening. And I would like to welcome a representative of the chemical industry, of the Association of Chemical Industry, Dr. Pierre Gröning. Please, Mrs. Yildiz, you start. Yes, thank you very much. I would like to talk about the obligations of the chemical industry, first of all, and what they could say about the directive. The chemical industry, of course, has huge consequences on the climate and on the environment, and also a high energy need, more than the steel industry and the cement industry. Plus, plastics production needs a lot of oil, needs a lot of energy within the EU, and this development will continue in 2050. The petrochemical industry will probably be the highest user. And why? Because there's an increase in plastics. But this doesn't need to be like that. If we apply obligations for the entire value chain, like we demand, amongst others, this development can be limited because companies will then use these obligations also to reduce these climate and environmental consequences within their supply chains. And what is good is a lot of changes already in the industry. There is an initiative of the chemical industry in that respect. Unfortunately, they do not say a lot or hardly anything about climate protection and environmental protection. This is a pity, but this is also perceived as a problem of the sectoral obligations. And if there is such a high level of obligations, yeah, it is no wonder that they are against it. What I criticize is that the legislator is not ambitious enough. We hope that this will not be the same case within this EU directive. We want really strong environmental and climate obligations in order to raise the bar for the companies in this respect. Thank you very much. Dr. Pierre Gröning, you have the floor now, representing the VCI. Yes, we're in the middle of the chemical industry and pharmaceutical industry, which I also represent. They subscribe the 2050 targets. The question is more, how do we want to reach that target? One starting point is a development which we have been seeing for several months, if not for years. Europe regulates the path towards this change. Other countries act. Emission-free locations of the chemical industry are now being built up, Bayer in the US and others in China, for example, not in Europe, which means we will be caught up by reality soon. This is on the one hand positive that other countries go such a path, but on the other hand, we have something to do as well. As far as the obligations are concerned, we have concerns with the stipulation of these principles. The complexity of the supply chains was already mentioned. This is huge. I think about big companies, they have 70, 80,000, 90,000 suppliers on the first tier, and you can continue that with every step in the value chain. a multiplication takes place of these suppliers with a contractual period that is limited. There are huge data which need to be generated for the climate and environmental changes. Secondly, unfortunately, I would say this field is not very pronounced in terms of environmental aspects. We have with the ILO quite an established network. This is now a relatively new area. There is not enough knowledge maybe how this should be all implemented. What do we demand? Limit the entire law, especially as far as these two topics are concerned. Accept sector standards. I'm sure we have to do more. We have to go into more detail. There's a lot of more potential, but to recognize that would be very important. Thank you very much. Anna, you have the floor. Yes, this is a very exciting debate, I must say. Mr. Gröning, it is really great, I must say, that many companies, and especially chemical companies, are on the path or subscribe to climate neutrality. And I must also say it is important that this will not be discontinued. This is a bit of a problem at the moment in the parliament. Another target to be achieved, I know you know that, but I would like to say that again. Of course, it is very important that the chemical industry and other sectors go and develop towards climate neutrality, and they are being supported, of course. But what cannot happen and must not happen is that the suppliers within the supply chain continue to pollute our rivers and our air, for example. If you read all the reports, and I think it is actually important to do so that we stop talking about an abstract problem, because if people in India, for example, are being injured because of certain chemicals used for coloring textiles, this shows how important it is to do something about that. And therefore, we as the Greens made this a priority, also because it is a weakness in the German law, as Mrs. Yildiz said. And I must say, this was also within the European Parliament during the discussions. Tomorrow it will be very exciting, again, to find a consensus. Okay, we have the Green Deal, but how can we implement it in the supply chains?
Okay, Ms. Yildiz. Thank you very much. We just heard of a problem in practice with regards to human rights due diligence obligations, and that is a lot of companies do not know their suppliers have very complicated value chains and therefore also do not know what emissions they cause. And in practice, often on the basis of the purchasing amount multiplied by the average of the emission, the scope 3 emissions are then reported, or rather calculated, for each product. And that's not sufficiently accurate, which is why I must know my suppliers so that I obtain the concrete data set. But and I'm repeating myself, it's also an issue with regards to human rights due diligence obligations. So I don't find this argument with regards to the climate very convincing, because a start has to be done somewhere. And due diligence would also include supporting the identified suppliers when it comes to transitioning to renewable energies, because that in itself would lead towards a decarbonization of my supply chain. And now with regards to the question, what due diligence obligations mean, because the legal uncertainty was mentioned that many companies have. Well, this is a debate that is ongoing, but it basically means that companies have to ensure that the supply chain targets the 1.5 goal of the Paris Agreement, and the adjustment measures must be implemented. And one could perhaps have a greenhouse gas budget for a company, which would allow for all of it to be tackled. So one might say the company has a budget which is determined by its share within a specific sector in total emissions. And then on the basis of this budget, certain emission reduction goals can be defined. But for this, there simply isn't sufficient knowledge at this point in time, and one requires total knowledge of the supply chain for this. Well, this is a very enriching discussion. Two aspects. Indeed, there is a debate with regards to setting climate goals, and when it comes to putting numbers next to these goals. And one option would be to say this is a running debate, which doesn't mean that one shouldn't take up developments within this law. A gradualization could be possible. Some things can be measured today already. These things could be covered in a law today, and other things could develop. Laws often contain review clauses that stipulate that in 3 to 5 years, one takes another look at the law to see what the market can give. I'm convinced that in a few years, we'll be able to much better measure CO2 footprints within supply chains. So a lot of things are happening, but my impression is that perhaps with this law, developments won't be sufficiently considered. As for the chemicals industry, we do have a lot of emissions. We are aware of the fact that we are in part responsible for climate change. We're also the first ones who are doing their utmost to reduce emissions. And I think this is also a model that can be exported abroad. In part, other countries are also already surpassing us, which is of course positive. In Europe, we have a good REACH regulation. A revision of this regulation is foreseen for the end of the year. So I think Europe is indeed a pioneer here too. But I'm not sure whether this can be solved via the Supply Chain Act if other countries do not follow suit. Now, with regards to the sectoral initiatives, this has been mentioned a few times hitherto, and the federal government of Germany also supports the sectoral approach. But I think here too, the law can still be improved. Thank you very much. Right, that is the end of the bigger round. It took longer than I thought, but I agree with Mr. Gröning. It was very enriching. Anyone that would like to take the floor could now turn on their camera. We have a bit more than half an hour left, and we could perhaps now start with our broader discussion. Well, now I'd like to give all of you the possibility to react to each other for 15 minutes. If there's anything extremely important to you, if there's any further point you'd like to make, simply raise your hand so that we can do one large round. That could be a possibility if there is something pressing you'd like to state. And after that, I'll ask for the audience to join us. If that isn't the case, then, oh, okay, Mrs. Meyer, please. Thank you. I'd like to react to what Mr. Gröning has said. You said that not all suppliers can be found, but the concepts of due diligence for which the OECD has already developed a few standards contains one core element. And one core element is the progressive further development of what is being expected of companies. So it recognizes that at the beginning, companies do not have all the knowledge and cannot recognize all of the risks. But the expectation is that the company is going to increase its capacities when it comes to this. There's also the element of prioritization. So, if a company identifies a number of risks that cannot approach or tackle all of them at the same time, and the company can decide which ones are the most important risks. And when I say important, I mean how big the potential damage would be and how likely is it that this damage comes about. And of course, here the company cannot simply say, okay, I'll only do this. There must be the aim to also tackle the other risks at a later point in time. So there must be the capacity to address more risks in the future in the course of timely development. But what's important is that it isn't expected of a company immediately to be able to do everything right from the onset. There's a learning element, there's a further development element, but all of that under the condition that at a certain point in time, all of the risks are going to be tackled, and that there isn't sufficient capacity to identify risks or to address these, that these capacities are then gradually developed. Thank you very much. Very, very important point. Before I give the floor to Mr. Kunze, I'd perhaps like to ask Anna Cavazzini. We heard it, prioritization, timeliness, what is foreseen? How much time do companies have, and who will decide when it comes to liability, for example, when it comes to civil liability, who is going to say, this company now had 3 years' time but didn't do it? How strictly will this time factor be regulated? And after that, I'll give the floor to Mr. Kunze. Well, generally speaking, there's an implementation time frame. And in the current proposal, 2 years are foreseen, but that will also be subject to negotiations with the Council. But there is an implementation time frame. And the Parliament compromise currently foresees a gradual model that one starts with a larger company size, and then after a few years, all companies join. After 4 years, as of 500, and then we'll go down to 250. So it will take a while until, or a while will go by until such due diligence mechanisms need to be set up in smaller and mid-sized companies. And after the implementation of the EU directive, authorities can, of course, also foresee fines if companies do not do justice to their obligations. That's the overall framework, but it hasn't been fully negotiated yet. Right, that is also a response to one of the most important questions that were asked, and that is the question relating to controls and inspections. But perhaps we can talk more about that later. That is indeed an important question. But now I'd like to give Holger Kunze the floor. Prioritization is a key word. In Brussels, the sun is shining, so hopefully you can still see me okay. Now, prioritization. During the debate, we had made the proposal to work with so-called whitelists. The idea is to say, okay, we're going to place certain countries onto a list, and this list exempts companies from having to examine supplies from these countries. Now, the European Union, as part of such a whitelist, would make a lot of sense. And if we speak about prioritization, this would, in my opinion, certainly be the right step into the right direction. Thank you very much. Ms. Yildiz, then Dittmann, and then Mrs. Reinwald. I'd like to say something about this step model, this gradual process. And when it comes to the adoption of the directive, currently, according to the current proposal, one foresees that the obligations will only come into play as of 2028. And in light of the incredible speed of global warming, this isn't the right thing. This is probably a result of the compromise within the parliament, but this is not adequate in our opinion. And now with regards to the whitelist, this is a proposal we rigorously reject. There's a lot of problems within the EU, including the meat processing industry in Germany or the waste sector in Bulgaria. These are examples that things aren't running that greatly in the European Union, which is why this whitelist approach, in my opinion, isn't apt to find the right solution. My question would then be, what about the internal market? We assume that general rules are adhered to and that these countries are disadvantaged in the internal market if they have bigger or higher due diligence obligations than in other countries. In Europe and also in Germany, we are very highly regulated, but nevertheless, and I also wanted to say something about this whitelist. Nevertheless, we also have violations of labor laws. We have violations relating to the right to assemble, for example. Generally speaking, this should be taken up in national law. And then there was a scandal with tennis and the meat industry. And not too long ago, in Germany, we had a strike that was organized by Polish and Georgian truck drivers. And the transport sector is associated with great risks. And if all companies adhere to the due diligence obligation, this still means that we have to tackle this step by step. And we have companies that have shorter supply connections. And if the biggest risk is to be found in Europe, then this has to be prioritized. Thank you. Mr. Gröning, and Mr. Kunzing, and then Mr. Kampfhöhner. I'd imagine that everyone wants to say something about the whitelists. If you have something to say about this, do raise your hand. Otherwise, we'll close the speaker list. Otherwise, I don't think we'll manage. Mr. Gröning. I was somewhat shocked that there's very little trust within a legal space. That treaties aren't sufficiently adhered to.
Fleischbetrieben oder bei Tönnies oder ich weiß nicht wo letztendlich dann entsprechende Regeln eingehalten werden. Also ich glaube, dafür gibt es auch nicht.
In my opinion, there is the rule of law at a European level. I don't think this is something that is going to be settled by a supply chain law. I believe that a risk assessment is the right approach. We need an intelligent system that learns where the biggest risks are and what needs to be tackled. And even though Europe isn't perfect, Europe also wouldn't be the first space I think of. And I'd also like to mention another aspect that was already mentioned. And that's the implementation that is going to take place in 27 member states. How are we going to ensure that, for example, Bulgaria, Romania, or Poland have a similar implementation with a law, with the implementation of the legal text, but also with authorities that do justice to what is expected? That could be a weakness of the law that one regulates, but that one doesn't have the means for authorities to ensure that the implementation does take place successfully. Mr. Kunze, with regards to the whitelist, that there are black sheep in Europe is clear. That there are issues in Europe is something we can all agree with. But it's all about prioritization and the question how we can make the supply chain law enforceable for SMEs too. and the difficulties we should focus on and to be found in Europe or in Western countries when it comes to this. Thank you. Mr. Kampfhöhner. I agree, surprisingly, with the previous speakers. When it comes to the whitelist, we have something in the European Union called acquis communautaire, where all of the legal stipulations can be found. And this can also be enforced at ours, and that indeed makes a big difference. Because if I have the means to implement this at a legal level, then I have to consider whether I want to legislate twice. I don't think this is required. I've been here in Brussels for over 20 years, and I don't think we require more bureaucracy. We should indeed simplify companies' lives. The word enforcement was already used. Because we can enforce this at ours, I think whatever's already regulated doesn't have to be included into the act. And the last point, there's the role of the state. The state has very few obligations in this directive. One would hope that countries such as Canada, for example, when it comes to many points and standards, Canada is comparable to the EU. So one could say, okay, the Canadians already ensure so well that the rules are adhered to as we do so in the EU, so that perhaps Canada as a country could be placed onto a whitelist. This would simply make sense. Thank you, Anna Cavazzini. Thank you for giving me perhaps the possibility to make some final remarks. I also do not believe that we do not need this whitelist because there are issues within the European Union. I'm the chair of the Committee for Internal Market, and it won't surprise you that I say we have clear standards and rules in the internal market. Often there are enforcement issues, that's true. And a lot of the cases that have been mentioned are enforcement issues and not regulation issues. But nevertheless, I have been against this whitelist approach in negotiations because I believe that it's incredibly difficult to decide what country is going to be placed on that list and which one not. There are going to be sufficient countries where one can say, these are Western countries, but where nevertheless human rights violations take place. And secondly, it's also easier for companies if there is a due diligence system that is based on risk assessments. And automatically then, if one imports a product from Canada, one wouldn't think, okay, this is my highest risk. It is perhaps somewhat more risky if I get a raw material from a mine in Congo. So this risk-based approach already allows for different weightings. But I wouldn't say that it would be easy to say, okay, this country can be placed on the whitelist because there are absolutely no human rights violations.
Die topgevoteste Publikumsfrage ist von...
Now we will answer the questions from the public. Somebody, anonymous laws are nice, but it's the same like with the labor laws, where you have no regular audits, it's only a paper tiger. How do you want to do that, including NGOs, trade unions from abroad? So the question is, who can really report violations within the supply chain? Maybe we could differentiate between EU and non-EU countries. Anna, if you want to answer the contents-wise, but I also would like to hear the opinions. And to all of you, if you know good practices from companies, etc., please give us some examples, because this increases the transparency, how that can be done locally. Maybe that was a bit abstract, but I think you know what I mean. Mrs. Dittmann, please, and then Mr. Lange. Okay, I will start. A question how to implement. Yes, that was the question. Okay, that's why we think it's so important that trade unions, employees, representatives are really included in a structured way via a network. We need to assure the implementation, the enforcement. Generally, every company has a certain or has to have a complaints mechanism or an umbrella complaints mechanism, and employees from the international companies or people living near this company, anybody who thinks he is affected by a violation has a certain body he or she can turn to and can complain. And if one does not personally complain, this can also be done via NGOs or via trade unions. And generally, I think, and this will be my final remark, I think it is tremendously important that you do not only create and promote an auditing industry. No, companies have to really take the initiative. They have to check and they have to know themselves what happens in order to improve the situation generally. Thank you very much. Those I mentioned now, Mr. Lange, Mrs. Reinwald, and Mr. Kamphöner. That will be all to this question. Mr. Lange.
Yeah, no, there are very practical examples of how that can be done. And in the case of cocoa, I work for a very, very fragmented supply chain where your suppliers are millions and millions of smallholder farmers. But in practice, this is perfectly feasible to know where your cocoa is coming from, who has produced this cocoa, how this cocoa was produced, and what are the risks associated to the production of that cocoa, not for the company, but for the people who are producing that cocoa or for the environment. So indeed, this is not the auditing or certification business that can solve those issues, because it's not a kind of spot check going from time to time to a handful of farms that is going to allow you to identify those problems. This is about working with these so-called affected, vulnerable people at the bottom of supply chains, involving them directly in those monitoring systems. So we have ourselves put in place very robust systems that have not only proven their efficiency in terms of identifying cases of child labor, identifying vulnerable families, identifying vulnerable children, but also remediating those issues. So if you put the right resources, technical and financial resources into place to do so, if you're directly involving those people at the bottom of the value chain in the assessment, when they do the monitoring themselves, in our case, cocoa farmers, their wives are directly doing the monitoring, then that works in terms of identification of issues. But most importantly, that works because there are prevention, mitigation, and remediation mechanisms. So you're not there to punish poor farmers who have no alternative than to using their children. You're there to provide support. So if you've got this right mix, then in practice, this can perfectly work. And if that can work for smallholder agricultures and millions of smallholders, then I struggle to understand some of the other speakers on why that cannot work for factories and other, in my view, more structured supply chains. Thank you.
Vielen Dank, Frau Reinwald.
Thank you very much, Mrs. Reinwald. Yes, a legal regulation. There are two implementation mechanisms, civil liability on the one hand, that you can complain, and on the other side, the agencies that can do something. And in Germany, what we are lacking in our supply chain law is the civil liability. And that's what we see in the enforcement, that partners in another country are really disappointed that when they complain, they will not receive compensation. But we have at the moment in the German Act not a mechanism which gives justice also on a court level, and which would mean it would create precedencies. And it would mean that companies know, I really have to do something. I have to take preventative measures. People, victims are complaining, and I have to take that into consideration. This is a very important mechanism that needs to be part of the directive. It is important that they have the possibility to go to court. There need to be not so many hurdles for them to do so. There is not yet a fair distribution of the proof of evidence at the moment. For the victims, for example, it is extremely difficult to get information whether the company actually met the requirements they have to meet. And then the agency side, this is also supposed to be included into the directive. At the moment in Germany, we are collecting experience with the export control agency, but what we don't have in the German Act is a clear information how high a financial sanction is going to be and how is that going to be measured. We need an authority enforcement and implementation. The draft foresees complaints possibility, which means that victims can also approach the authorities. And it should be a process of learning from each other. There is supposed to be a network of these supervisory authorities. And I'm sure in future it will be very important that we in Germany make progress in terms of our German supply chain law. And that means we need to have a good supervision from the authorities. Mr. Kamphöner. The possibility to complain as an association or those affected. I think in Germany, as far as enforcement is concerned, we have a good principle in our law. If I go to court, I must prove that I am affected, that I am a victim. This is part of it. And this has to be something the state has to make possible. What we cannot include that everybody says that he represents a social interest, and that means I can do something against company A, B, and C. What is important that victims are being supported, that this is organized, for example, via trade unions. Trade unions support individual employees when they want to get their right, and this is good. But there has to be a balance. There has to be the right proportion. The legal system is there to give legal protection to those who are real victims, and this is how it should remain. I close now the list of speakers concerning this topic. We will have a final round, Mrs. Meyer, where you can say something, but now I would like to continue with two public participants. Mrs. Hof, first of all, please, your question, a brief question if possible. Now she's surprised, I suppose, that she has the floor. You have to unmute, of course. No, it doesn't work. Okay. Then Mr. Lautenschläger, I ask you whether you would like to ask another question. Mr. Lautenschläger. Yes, of course, I take this opportunity. There were a lot of keywords mentioned, which I found very interesting. Export control provisions, which are in existence, that was mentioned. And furthermore, we have an enforcement problem and not a regulatory problem. That was said by Anna. And my question is now, why do we never mention the audit authority called Customs Office? Mrs. Reingard mentioned that there is a network of authorities, and I hear now nothing about the possibility for the Customs Office to check. We're talking about a lot of import-export activities. the living conditions of people in India, that was mentioned. You mentioned production facilities, but you didn't mention anything about imports. And why do you mention nowhere in this directive that the customs office can control and check something everybody wants to have, but nobody includes this authority that can actually do that? Thank you very much. I have two possible answers. Mr. Kamphöner. Thank you very much, Mr. Lautschläger. You mentioned the customs office and export control. I mentioned indeed export control because the way it is regulated within the EU, I think that is a good example of how you could do that. Export control means the state provides a list with countries and with names after a diligent check, and then the company can make business with these mentioned countries or not. And this is something which would be useful for the directive. Customs Office, there was a suggestion 2 weeks ago by the European Commission. The entire customs administration should be renewed. There should be an European customs administration. And the competencies of this customs administration should be extended. We will not have enough time to talk about that, about international trade. If you go to the website of the Commission, you see a lot, you find a lot of information. This is all in English only at the moment, unfortunately. A lot is being discussed. The question is, what will be the extent of it? But there are proposals made by the European Commission. They're there. Mrs. Meyer. Export controls, the export control provisions of the EU, they mention explicitly the due diligence obligations. You have to differentiate. The background is, of course, security questions. And even though it is mentioned expressly that in special areas there are security risks being identified by the governments, but nevertheless, there is the obligation to do due diligence by the companies to identify certain risks. This is different to the directive concerning export, for example, dual-use items, those items which can be used in a civil environment, but also in a military environment. The law works on the basis there that the company has to meet due diligence obligations. This is one thing. The customs discussion, the transposition and the implementation, and which authority will be responsible, has not been approached yet. This is something that will be discussed after the directive on the supply chain. But the customs administration was mentioned again and again. Also, as far as the customs code is concerned, how transparent is that? And of course, it would be great if the customs administration would be included as a potential authority for implementation. Thank you very much, Mr. Gröning, and then we go into the final round. Yes, just very briefly. I think this directive we're talking about and other laws have the problem that one doesn't think enough about implementation. Mr. Lautschläger mentioned this will be applied to national companies, EU companies, and companies abroad. And what is not included are import articles. Logically, you could think about Chinese products, for example. They are not covered by this provision on the one hand. And if that was the case, I think the customs authorities simply do not have the possibility, not the technical means to do that. There is a gap as far as enforcement is concerned. This is quite an important gap, unfortunately. And I think this is something we have to take further into account. Thank you very much. We now enter a final round. Anna Cavazzini will have the very last word. That's why she will be the final speaker. I put the question into the chat as well so that you all saw it. Please give us a short answer, less than a minute, maybe half a minute. Just tell us what you would like to change. If you all now had the power to include something into the positioning, something that will be included in the directive, what would you change? Just a couple of sentences or three. I start from the bottom, just like Zoom says. Mr. Kamperner, you start therefore. What would you change if you had the possibility? One thing. Wow. Then I could repeat what I just said, my entire speech. Well, check again what the small and medium-sized companies can do and find a better balance. The idea is good, but as far as enforcement and implementation is concerned, one could change a few things, not only one. Mr. Lange, next on my list.
Make sure that it works for affected people and smallholder farmers who are at the bottom of value chains.
Frau Dittmann.
Mrs. Dittmann. I would make all companies really responsible, of course, according to their size and risk disposition. And what is important, that the employees' representatives have a stake, inclusive the trade unions. That is very well done. My compliments, Mrs. Reinwald. I would like to have less hurdles for those who want to go to court, so that those who have the right really can profit from this possibility. And that tomorrow, when the vote is done, this compromise finds really agreement, and that the strong points will be in the directive also after the trialogue. Mr. Kunze, I would like to see that also the SMEs of the machinery equipment companies can do that, that it's doable for them, and the whitelist is important. Mrs. Yildiz, ambitious climate targets with emissions reduction applying to the entire supply chain, also downstream. That should be included in the directive. Mrs. Meyer. The reverse of the proof of evidence. That means companies will have to prove that they indeed met the obligations of due diligence and that not the victims have to prove anything. Mr. Gröning, reduction of the liability down to one tier. And Mrs. Cavazzini, you have the final word. You have the floor. Well, if I see how different these ideas are, maybe we found quite a good compromise, and I hope it will be voted on tomorrow. And I concur with Mrs. Reinwald, and I would like to use this half second to say again, we are still working on a twin law, import prohibition for products from countries which have forced labor. So this is an approach that they cannot really be sold on the internal market. And I think this is very exciting. Maybe we can organize another webinar about this topic. And I would like to thank Max very much for organizing this webinar and everybody else for the discussion. I completely agree. Thank you very much to all of you who took 2 hours time. I would like to thank our interpreters who did a great job. This is not so easy when we have so different in speakers. So thank you very much to the interpreters. Thank you to the team of Anna who co-organized. Thank you for everybody who promoted our webinar. And I would like to finalize with the following word. We have a tool, the NGO Supply Chain Act, have a tool where you can write to your members of parliament. If you are of the opinion, please do not vote in favor of this directive tomorrow, you can write that too. We heard arguments in favor and against, but I must say none of our guests said that this directive should be stopped tomorrow. I think there is the general desire that something like that should really be put through. Nein, Mr. Kamphöner, okay, no, I withdraw my comment. Others do not support the directive. Please use that tool. I put it in the chat. You can give your opinion. You can say whether you find it positive or not. It is important as a citizen to use all the possibilities one has to have a say. Thank you very much. I thank you all. I wish you a nice evening. I will say something else. We continue. We have the next webinar about climate lobby, anti-climate lobby. And we will have a close look at that on Monday with experts. You can see the link now in the chat. Thank you very much, and I wish you all a nice evening. Bye-bye.